We're here with forensic psychiatrist Dr. Alan Berns. Dr. Alan Berns, can you tell us a little bit about the origins of competency to proceed and how
Yeah,
that standard works in Florida?
yes, Faith. First, thank you for inviting me to participate. Competency to stand trial means that somebody legally qualified, is somebody competent to perform a particular task. You could be competent to make a will, you could be competent or not to stand trial. Competency is task specific. As I said, somebody can be competent, for example, to decide to participate in a research study, but not competent to stand trial. Competency is the here and now. So when I evaluate somebody for competency, I'm not concerned how they were at the time of their arrest. It's how they're doing now. Do they have the mental capacity to participate in court? Competency itself derives from ancient times, when even talked about the fairness or not of somebody committing a crime who may have been mentally deficient of being able to participate and stand trial. It's very important also for the not only for the person to have justice, but also to make sure that this trial itself is not a mockery if somebody is not competent. Competency to stand trial based on Florida statute. First of all, you have to decide whether or not there is a mental illness or mental defect. And then we have main areas. Does the person understand what they're charged with? Do they have an understanding of the range and nature of the possible penalties? Do they understand the adversary nature of the legal process? In other words, do they know whether or not there will be a lawyer who is going to be asking them questions who is against them and trying to prove them guilty? Does the person have sufficient intellectual and rational understanding to be able to assist their attorney in planning a defense, go over the facts of the case, help decide with the attorney whether or not they want what kind of defense they may choose, type of plea? Does the person have the ability to manifest appropriate courtroom behavior? Will a person become agitated in court, start screaming? If you have a person who is psychotic and who is responding to internal stimuli, will they be mumbling to themselves? Will they be having mannerisms that may detract from courtroom demeanor? Competency to testify. Is the person's thoughts, are their thoughts rational, logical, coherent? Uh, will they be able to testify? Do they have significant problems with their memory, with their recall? Competency from the Supreme Court, famous case of Dusky, where a person's court decided that a person has to have a present sufficient ability or capacity to assist or consult with their attorney. Do they have a rational as well as factual understanding of the charge against them? How does a competency evaluation, what does it consist of? Typically, as a psychiatrist, I do a psychiatric evaluation. I obtain, first and foremost, a history, social history, psychiatric history. Is there a history of substance abuse? I want to know the background, their educational system, level of education. I would like to know, is there a family history of mental illness, as some illnesses can run in families? Do they have medical problems, issues that could affect their mental state? After doing a history, I also will then want to do a mental status examination, which is a here and now study of the person in front of me. Study their appearance, their mannerisms or lack of. Is their speech coherent? Is it logical? Do they go on tangents? Are they experiencing any hallucinations, which can be in any of the five senses, auditory, visual, olfactory, tactile, gustatory, which could affect their ability to participate in court? Are they experiencing delusional thoughts? For example, do they feel that there are people out to kill them? Do they think they're famous and that they could do whatever they want because they have this great notoriety or celebrity, which could affect their ability to participate in the court system? Is the person depressed or not? If they're very depressed, they may lack motivation to help themselves. Are they having thoughts of harming themselves or others, which certainly is important to assess in their competency? Are they oriented? Do they know what the date is, where they are, who is around them, what is the context of this interview? We do checks for memory, Remote memory, recent memory, in particular immediate recall. If a person cannot recall what was said to them a few minutes ago, it may impact upon their ability to testify in court. We evaluate things of judgment, abstract cognition. In doing a competency evaluation, it's important also to look at third-party documentation, arrest reports, witness statements. The person may appear to be incompetent, but yet if they were arrested recently and they seem to, depending on what they state to police or other people, you may have a question as to whether or not they may be fabricating signs and symptoms of mental illness, which can occur. Competency is probably the most frequent raised issue in regards to psychiatry and the criminal justice system. Competency is dynamic, not static. In other words, I can evaluate someone who's I feel is competent today. A month down the road, maybe they're still in jail waiting for trial. Stress levels may increase. Maybe they're not compliant with their medication at that point in time. They may no longer be competent. Competency can be raised by anybody in the criminal justice system. It can be raised by defense counsel, by state attorney, or judge. Competency can be raised at any time during the process. Could be prior to trial. It can be during the trial if somebody all of a sudden acts in a bizarre manner. The judge may have concerns and say, we have to put a halt to this. I need to order a competency evaluation, preferably on an urgent basis.
Can you speak a bit about how competency differs from sanity under Florida law?
Yes, well, under Florida law and also in other statutes, other jurisdictions, competency, again, is the person's current mental state, the person's current ability to work with their attorney, to understand the proceedings of the criminal justice system. Sanity is what the person's mental state was like at the time of the offense. So there we have to go back in time. So the main thing to remember is competency is the here and now. Sanity is the past mental state at the time of their arrest or allegedly having committed a crime.
Let's delve a little bit more into sanity. Can you talk about what the origins are of our laws in regard to sanity?
Many of our sanity laws derive from England, and in particular, there were a series of attempts in England in the 1700s, 1800s on politicians, even on Queen Victoria. And there was a concern as to whether or not some of these people had an understanding of what they were doing. In other words, did they understand the nature and consequences of their actions at the time of the alleged offense? Did they understand or able to understand right from wrong? Of course, this is our current concept on the McNaughton. This was slowly evolved, throughout the years. Sanity, basically, under Florida law, does the person, first of all, have a mental illness or mental defect? And second, as a result of the mental illness or defect, did the person not have the ability to discern right from wrong at the time of the alleged offense or commission of the crime? And were they not able to understand the nature and consequences of their actions at the time of the alleged offense? Sanity, keep in mind, is a very difficult defense to prove. The burden is on the party raising the issue, which is the defense. And more likely than not, historically, and sanity is very difficult to prove, and most of the time it is not successful in court.
In what ways does the sanity exam differ from the competency exam?
Very good question. Of course, in examining sanity, I will still do many things that I do for competency. I want to obtain a complete history. I also want to make sure that they're competent at the time I'm examining them, even though it's for sanity, so I will go through the mental status examination. But here we have to go back into the past. So here, first of all, I want to find out their self-account of what they recall at the time of the alleged offense. I need to have documentation. Again, police reports, witness statements, family members may be helpful if they recall the person's mental state at or around the time of the alleged offense. Any mental health records, which of course are important not only in competency but especially important in sanity, but regarding the person's description of their person's mental state at or around the time of the crime. So in other words, if I'm doing a sanity evaluation, I will ask the defense counsel, public defender, can you please obtain any documentation from any mental health professionals, hospitals, or the jail records regarding the mental health people who work in the jail that may describe the person's mental state at that time. It's also important to try to understand, if the person at that time was under the influence of alcohol or street drugs, which then could skew or negate the raising of an insanity defense.
And can you talk to us about the difference in terms of mental illness affecting the defendant's mental state at the time of the offense versus alcohol or drug use?
Yes, again, the Florida statute says the person had to be suffering either from a mental illness or mental defect. A mental defect could be someone who, for example, has an intellectual disability or a dementia process. If a person is under the influence of alcohol and or street drugs such as cocaine, LSD, or other street drugs, that independently could cause them to not have understood what happened, what they did, but that does not equate with insanity. That is not the statute. Voluntary intoxication of alcohol and drugs does not equate with insanity.
And how does McNaughton relate to the Florida statute?
Florida statute is based on McNaughton, again from the famous trial in England, where in Florida we follow again, does the person suffer from mental illness or defect because of their actions? Was it due because they lacked the ability to understand the nature and consequences of what they were doing, or were they not able to discern right from wrong? I also like to state that the insanity defense is not accepted in all states. There are 4 or 5, at least that I know of, that do not accept that. There have been different evolutions of the insanity defense. For example, there was something called the Durham rule, where someone who suffered from mental illness in and of that would be exculpated from the crime. But that in Florida we do follow these statutes.
What is meant by the phrase guilty but mentally ill, and can we use that here in Florida?
To my knowledge, we don't use that in Florida. You may have those in some states. It may be in Wisconsin, where a person who is mentally ill commits a crime and is found guilty but mentally ill, meaning that they're still considered responsible for their acts, but because guilty but mentally ill, that may help in terms of what I understand to be some sort of mitigation. But basically, they're still held accountable for their actions.
In your opinion, should we use that standard here in Florida?
There's a lot of controversy. I believe still in the McNaughton rule, because I have seen some individuals over the years that when you go back in time, they were in a manic state or psychotic, and in my opinion, they should not be held accountable for what they did. But I can understand where other people feel that people should be found guilty but mentally ill. But I still believe that there should be exceptions where people should not be held accountable because of their mental state.
And what happens next? Let's say a defendant is found not guilty by reason of insanity. What happens to them next?
Right. Well, if a person is found not guilty by reason of insanity, then mental health professionals, psychiatrists, psychologists are then asked to decide, does the person need further treatment, and is the person considered to be at risk of harm to themselves or others? And if they meet that criteria, depending on whether they at risk of harm to self and others, which therefore would mean that they meet criteria for hospitalization, they may be transferred, sent back to a hospital, forensic state hospital, for further psychiatric treatment. At some point, if their condition improves, they may be downgraded to a civil hospital. There are cases where if a person's condition improves, there may be evaluations to see if they no longer need to be followed by the court. You may ask for what they call termination of jurisdiction, where the court no longer has to be watching the person's mental health, where after a certain number of years, a period of time, if they're doing well, of course, this is done with evaluations, may necessitate court hearings. The person may no longer be under the umbrella of the criminal justice system. I know in certain states, like in Oregon, they have what they call an insanity acquittal, something to that effect, review board, where people are followed very closely. It's very important, in my opinion, to keep tabs on these individuals, especially if they have committed violent crimes, to make sure that they're compliant with treatment so as to not reoffend.
When should the issue of competency be raised and by whom?
The issue of competency can be raised at any time in the proceedings. It can be raised the first time defense attorney meets with their client if they have concerns about their ability from a mental standpoint to work with them, to consult with them. They may ask for a competency evaluation. I've seen cases where even in the middle of a trial, the judge may have concerns about a person's competency depending on how they act or behave or respond in court. They may ask for an evaluation. Anybody can raise the issue of competency, can ask for an evaluation. Even state attorney has the capacity to do so.
Can you talk about the Florida statute and those criteria?
Yes, the Florida statute says for a person to be considered competent or incompetent, you have to follow the statute, meaning, first of all, does the person have a mental illness such as schizophrenia, bipolar disorder, or some other mental illness, or have a mental defect such as intellectual disability, which is formally known as mental retardation, or could they have a dementia process, a cognitive impairment? That is the foundation, because a person, even though they may not understand what is going on, may not understand the law, if they don't have a mental illness or they don't have a mental defect, that would not necessarily make them incompetent, because you also may find people who are not willing to participate or do not want to work with the attorney. But you have the six, call them criteria within the statute. First, does the person have an understanding, a factual as well as rational understanding of the charge against them? Do they understand, for example, that they've been charged with murder? Do they have an understanding of what the ramifications can be, which actually goes into the second criteria? Do they have an understanding of the range and nature of the possible penalties? Does the person understand, for example, that they may face 25 years in prison? Do they understand what probation is? Third is understanding the adversary nature of the legal process. They understand or not that there will be somebody in the courtroom who will be against them, an attorney who will be asking them questions, who is trying to prove them guilty for what they're supposed to have done and would like to have them receive some punishment. Fourth, does the person have the ability to disclose facts pertinent to proceedings at issue? Do they have the ability to relate to their attorney, to disclose information to their attorney? This may also include their ability to realistically challenge prosecution witnesses. The fifth is, does the person have the capacity to manifest appropriate courtroom behavior? In the courtroom under stress, will they start yelling, screaming, become agitated? Will they start responding to internal stimuli? Or if they are already, this would make them not able to follow or satisfy this criteria. You need to have a certain degree of courtroom decorum to preserve the dignity of the process. The sixth, is the ability to testify relevantly in their own behalf. They have to be able to testify on both direct and on cross-examination. Do they have problems with their memory, which could affect their ability to recall what is being asked of them? Are their thoughts scattered, going off on tangents where they cannot stay on track? These are some factors regarding the ability to testify relevantly in their own behalf.
And can a person be competent to stand trial but not to plea, or vice versa?
The Supreme Court has said if a person is competent to stand trial, they should be competent to plead. But yet you may have different thresholds. If a person is competent to stand trial with the assistance of their attorney, but yet they want to waive their attorney, then they may not, and want to defend themselves, be their own attorney, depending on the situation, they may not be competent in that area. Certainly, for competency to plea, it's important that the person know what they're charged with, what the possible punishment could be. If they plead guilty without an attorney, they need to understand they're waiving certain rights. The right to have a counsel, the right to confront the accuser, the right to have a jury trial. So these are some of the things that they have to understand that they're forfeiting.
I've seen evaluations written to suggest that the client might be able to go through a trial as long as the courtroom was slowed down, the questions were asked slowly, they were given time. Would you say, in your opinion, that it's reasonable to suggest that the entire proceedings are dumbed down or slowed down in order to facilitate the defendant's mental state or intellectual state?
Well, we want to certainly have the person be treated fairly. It's difficult in today's court system to slow everything down so that the trial can take weeks instead of days. I personally feel that you may try to make some certain modifications. You might, for example, the person may benefit from using visual aids or cues in the court system. Again, I leave this up to the court, but it's also important to state that a person may be competent to stand trial for a minor crime such as trespassing, but not have sufficient mental capacity to be able to be considered competent to stand trial in a more complex and serious case such as a murder trial.
Thank you so much, Dr. Berns,
All
for
right.
your time.
Thank you for
Appreciate it.
inviting me. Thank you.